Welcome to GameChanger Law Advisors Simplifying the Law series. This is part 2 of the Trademark Basics video series. In this part, we will learn about trademark registration process in India. The process begins with filing an application for trademark registration. Let's break down the steps to be taken even before an application for registration of a trademark is filed. First, you must identify your trademark. In the sense, determine whether you want to register your trademark as a whole or if you want to register specific components of it as well, whether you want registration of your trademark in a specific color combination, etc. If the trademark you propose to register is already in use, you must identify the date on which the mark was first used and collate all documents supporting the use of the mark from such date. Using the supporting documents you provide, your attorney would draft a user affidavit in support of the user claim that you make in the trademark application. This user affidavit needs to be submitted along with the trademark application. Next, you must determine the class in which you need to register your trademark. You can determine the class to which the mark relates to using the International Classification of Goods and Services released by the World Intellectual Property Organization, also known as WIPO. This classification categorizes all goods and services under 45 different classes. You must also execute a power of attorney authorizing your trademark attorney or agent in order to enable him carry out the trademark registration process on your behalf. A copy of the same must be submitted along with the trademark application. There are totally 5 trademark registries in India. Based on the location of your principal place of business, appropriate trademark registry must be chosen to file the trademark application. And finally, depending on the nature of the applicant, appropriate fee has to be determined. Did you know that if your entity is a startup certified under the Startup India initiative, or if it is registered under the Micro, Small, Medium Enterprises Development Act 2006, the official charges are subsidized under the new Trademark Rules 2017. Once a trademark application has been filed and taken on record by the Trademark Registry, the same is examined to check if the registration must be objected. Objections may be on absolute grounds of refusal or relative grounds of refusal. Absolute grounds are invoked when the mark is devoid of distinctive character or contains any mark specifically prohibited by the Trademarks Act. Relative grounds are invoked when there are same or similar trademarks already existing on the records of the registry. In the event that the registry has objections to the registration, an examination report detailing the objections will be issued. A reply to the examination report with the submissions against the objections must be filed within 1 month from the receipt of the examination report. Otherwise, the registry may treat the application as abandoned. The registry might allow the application to proceed to the next step or issue a show cause hearing notice depending on the nature of objections and the submissions made in your reply to the examination report. The next stage is the advertisement of the trademark application on the Trademarks Journal. The registry releases a journal every week containing details of all marks that have successfully crossed the examination stage. This journal is open for the public for a period of 4 months within which any third party can oppose to the registration of any advertised trademark by filing a notice of opposition on valid grounds detailed in the Trademarks Act. In the event no oppositions are raised against your trademark advertisement, then your application proceeds to registration. However, in the event anyone opposes your trademark, the next step is the opposition proceedings. The opposition proceeding begins if any person files a notice of opposition within 4 months from the date of advertisement. The registry will do a formality check, and if the same is in order, it will be forwarded to the applicant. A counter statement has to be filed with the registry by the applicant within 2 months from the date of receipt of the notice of opposition. and within 2 months of receiving the counter statement, the opponent may provide evidence in support of his opposition in the form of an affidavit to strengthen his case. The opponent can choose to waive filing such an affidavit, but he has to inform the registry of such waiver. Similarly, within 2 months of receiving the evidence or intimation of waiver by the opponent, the applicant should adduce evidence in support of his application. The applicant also has an option of waiving to submit any evidence and can rely on the counter statement alone. Within 1 month of receiving the evidence or intimation of waiver by the applicant, the opponent again has the option to adduce more evidence in support of his oppositions. Upon completion of evidence submission stage, a hearing is appointed by the registry and the parties are notified of the same. The registrar, after hearing both the parties and reviewing all the evidence submitted, will determine whether the trademark should be registered or not, thereby bringing the opposition proceeding to a conclusion. However, the party aggrieved by the registrar's decision may challenge the same by filing an appeal before the Intellectual Property Appellate Board. On successful completion of opposition proceeding, the trademark will be registered. Please remember that the registration is valid for a period of 10 years and thereafter must be renewed from time to time. Thank you for watching part 2 of the Trademark Basics video series. Hope the Trademark Basics video series was informative. Please feel free to get in touch with us if you have any questions.